Oyez, oyez, oyez. Anyone having business before the King's Justice in the Superior Court of Justice, attend now and you shall be heard. Long live the King. The Honorable Justice Hennessy presiding. You may be seated.
Good morning, all.
Good morning.
Good morning.
Good morning.
Ms. Glassy.
There was a document that we did not complete marking as an exhibit after Ms. Jones was qualified yesterday. And that was a document at footnote 273 of Ms. Jones' report. And we had held off on having that marked. I did have discussions with Mr. Schachter and Ms. Lewis, as well as Ms. Evans, and everyone was content to have it marked as a numbered exhibit. My understanding is this document notice of appeal served on the council and attorneys of the record for the Dominion in the province of Quebec, which was printed in.
Let me just put it before me if you don't mind. Yep. Great.
And that document was within the larger document, which I believe was called Case on Appeal.
Yes. So what is being made the
The
exhibit?
entire document.
The document called Case on Appeal.
Yes, it's the larger document.
Very
I
good. That is
believe-
bound and you have handed up.
Yes, and I believe
Okay.
that's exhibit 97.
Had we given it any other name last day?
I believe it was Case on Appeal of Ontario, which was on the front of the document.
Right. And let's put 1895 on it. That helps us identify it. Case on Appeal of Ontario,
Yes,
1895.
thank you.
Whenever you're ready.
Okay, so we were working through Ms. Jones's slide deck when we finished on Monday, and we finished at slide 43, which is about implementation of confederation arrangements. So we're starting today at slide 44 regarding preparation for arbitration in 1868. So Ms. Jones, when you're ready.
So now we're at a phase where the confederation arrangements have been made. There has been some work done towards implementing the new confederation arrangements in the way of dividing up books and records, setting up new government departments, and beginning to draft the statements of accounts for the province of Canada and Ontario and Quebec as separate entities for the first time. And at this time, Canada was paying all of the bills that had come in from the province of Canada. Of course, at this time, there were still many financial arrangements outstanding that involved the province of Canada, for which payments were being made or payments were due. So the new Dominion of Canada was taking on all those responsibilities from the province of Canada. And Ontario was continuing to press both Canada and Quebec to establish the arbitration process and get it started. So in September of 1868, the Dominion sends Canada and Quebec a draft statement of the account of the province of Canada as of the 30th of June, 1867, together with a set of principles on which all the transactions since June 30th, 1867 would be recorded in the accounts. So this is just a set of accounting principles as to how to show all of these payments that the Dominion was now making on behalf of the old province of Canada and how all the revenues were being accounted for. And this is of course pending any kind of division between Ontario and Quebec as to the responsibility or the assets for these payments and revenues. So among the principles that the Auditor General, Mr. Langton, proposed was that, quote, the Indian annuities payable by the laws of the late province and the new Indian annuities, UC, that's Upper Canada, which have heretofore been voted annually, are to be capitalized at 5% and added to the liabilities. So the new Indian annuities UC are the Robinson Treaty annuities, because if you recall from previous testimony, they had never been included in the civil list. So they did have to be voted by the Province of Canada legislature every year.
And this proposal is being made by the Dominion,
Yes, the
Thank you.
Auditor General for the Dominion.
Langdon.
Right.
Thank you.
So what he's proposing is that he, in his, how the way the accounts are going to be shown, will enter an amount sufficient to yield the Indian annuities payable in relation to treaties made in Upper Canada, and add it to the liabilities, which means the liabilities of the Province of Canada. And Langton recommended this capitalization approach because the annuities, in his words, were guaranteed by a treaty and should not be subject to an annual vote. So there would be no uncertainty about the Dominion of Canada paying these annuities or being able to pay the annuities. The revenue from a capital amount would be generated every year.
Is this your conclusion? That there will be no uncertainty? Do you,
yes.
you proffer that as a reason?
Yes, this seems to be, to me, what Langton is saying, that because these particular payments were guaranteed by a treaty, not just the Robinson Treaty payments, but the payments for all the treaties in Upper Canada, that they should not be subject to a vote of the legislature, just as most of them had not been in the province of Canada after 1847, that there's no discretion by the legislature involved for these guaranteed payments, and that there's no risk that the government will not have enough money to pay the annuities. So he's proposing to establish this sum of money to be added to the overall debt of the province of Canada, which will yield enough money every year to pay all of the outstanding treaty annuities.
I just wondered about the word uncertainty. What I was coming to was, is uncertainty your view of the trigger for Langdon to say this? Because the last part of what you explained was so that the capitalization would result in a fixed sum that was already in the budget.
Right.
To me, that's like putting money aside. I don't necessarily think of it as certainty or uncertainty. It's I'm budgeting for that. If I put money aside for something, but you use the word uncertainty. I'm just wondering what that means, the same thing, or where it comes from, or if that's something that has been said.
Well, to me, and I think what Langton is saying here, if we subject this kind of expenditure to an annual vote of Parliament, there is necessarily some degree of uncertainty involved, in that Parliament could refuse to grant that in the annual appropriations. There could be insufficient funds because other spending priorities have been set to pay that obligation under the treaties. So what he is essentially proposing here is by these financial means to take the payment of the annuities out of the parliamentary appropriation process and include it in enlarging the Dominion of Canada's and through the province of Canada's overall debt to the extent that the investment, which would yield 5%, would automatically generate these funds. And there would be no longer any involvement or potential involvement by the legislature in
So it's-
whether or not these annuities are paid.
So it's a way of ensuring that they can meet their obligation.
Yes,
That's the purpose of capitalization.
right.
Ms. Jones, before we go to the next slide, I just wanted to ask you a question about your first bullet. Why was it important to Ontario to press on with the arbitration at that point?
Well, there are a number of factors in play here. One is that there were trust funds and other types of revenue generating assets over which Ontario wanted to have some control or to hold them for its own benefit, which were still being held by the province of Canada, effectively the Dominion in trust for the province of Canada prior to the division of assets and debts that was provided for under section 142. And of course, the other element of it was that once the amount of debt attributable to Ontario in this excess of debt calculation had been ascertained, Ontario would be paying interest on that, and that amount of interest would be deducted from their subsidies. So in order for them to be able to budget accurately, the provinces needed to know exactly how much money they were going to be getting in their subsidies.
And that applied to Quebec as well.
Yes. But I must say, Ontario is much more active on these issues than Quebec is. Ontario is the most active party in these arbitrations.
Can we turn to slide 45, please? I recognize that you've included this extract from JB tab 2770. Can you explain to us what this document is?
Well, I wanted to actually include a copy of the principles here for us to look at, just so that we can understand what kind of principles are in play. We've of course been focusing on the one that's specific to the Indian annuities, but I think it might be helpful to just have a little bit more context. So yes, we can make it a little bigger, that would make everybody happier. These are the kinds of situations that these principles were set out to address. So for example, the first one, when a service has been performed or a debt incurred before June 30th, which when paid would be charged against the consolidated fund, in which Ontario and Quebec are not specially interested. If the payment is made after June 30th, it is to be charged against the late province. So again, this is just, these bills are coming in from everywhere. There have been many commitments made by the province of Canada prior to Confederation. Bills have to be paid, revenues are coming in, and Langton, the Auditor General, is just trying to get agreement among all the parties as to how those payments and receipts of revenues are going to be shown in the accounts. Then the second point is about the balances of appropriations. So at the end of every fiscal year, there is usually some money left over in parliamentary appropriations. And this happened with the province of Canada. There were funds that were not spent within the fiscal year. So the second point, he is proposing a way of dealing with those appropriations. How are we going to show them in the accounts, and to whom are they going to be either credited or charged? So if we go over, and you can see the level of detail that these accounts include. You know, there's a sum for $8.15, which was supposed to have been spent on the indigent sick in Quebec, which is accounted for under Langton's calculations on this bullet point. So we just move over to the second set here. The item number 3, interest on the public debt and commission and charges that are on due July 1st are to be charged against the late province. Interest charges falling due after July 1st are to be charged against the province, that's the province of Canada, and the Dominion in proportion to the period in respect of which they accrued. So again, the idea is not just to memorize all of these points, but just to show the kinds of issues that they were dealing with, that on which Langton wanted to get the parties to agree so that he could at least set out a draft statement that they could use to take to the arbitrators. All of the parties could use to take to the arbitrators. Now, Canada is doing most of the heavy lifting on getting these accounts ready.
When you say Canada, you mean the Dominion?
The Dominion.
Thank you.
So Langton is doing a lot of this work, Langton and his staff. But as will be emphasized later, Canada did not believe that it was a party to these arbitrations. It's only participating in the arbitrations at this point to support Ontario and Quebec by providing information to which it has access and skilled staff to which it has access to prepare these accounts. So if we just scroll down a little bit again, if we look at, for example, items 8 and 9, they are to do with pensions. So pension commitments made by the province of Canada, he's proposing for these pensions, again, he views them as ongoing obligations that where a promise has been made to pay money to, I should say, a small number of pensioners. He is proposing, again, to capitalize those pensions and add the amount to the province of Canada debt. And this is also based on actuarial tables as to how long people are expected to live and how much money is required and that sort of thing. So he treats the Indian annuities, which is item 12, as he has treated the pensions. He looks at them in a similar way. If we can just skip over to the next column now, say we don't have to go through all of these, but this is just to give you a little more context as to what this looks like. And we'll go down right to the bottom bullet point, number 17. This reads, the lands in each province were surrendered to them subject to existing trusts, and the Dominion is bound to see that the trusts are executed. A very large sum, upward of $1,700,000, remains outstanding on sales of common school lands situated in Ontario, but in which Quebec has a joint interest, and the apportionment of this asset must be left to the arbitrators. So now this arises from the legislation and administration regarding common school lands, which I think I referred to a little yesterday. So this amount outstanding is lands that have been set aside at the time of survey. They're all in Upper Canada or Ontario that are identified as common school lands. In other words, when those land sales are made, the revenue has to be deposited into the common school fund. And that fund provides for education in both Upper and Lower Canada, or Ontario and Quebec. So there's a large amount of money outstanding because those lands have not been sold yet. And Langton is essentially saying here that this is a large asset outstanding. The money hasn't arrived yet, but it is expected to come at some point. So it's considered an asset. And how that is going to be divided up has to be left for the arbitrators. He's not going to make any attempt to do that. But of course, the first sentence in that bullet is also interesting as a parallel situation in which the lands in each province were surrendered to the provinces, subject to existing trusts. And this is the specific trust which Langton is describing here. He's thinking of these common school lands.
When you say in this bullet, you at item 17, you're
Right.
saying the first sentence of item 17, thank you.
And so Ms. Jones, at this time, is there a definitive amount anticipated in terms of resolution based on these principles?
No, all that's being established now is how to begin to set out these accounts. How to credit them.
We could go to slide 46.
Now, we've just spoken a little bit about the first bullet on this slide, what it means to really capitalize, and in this context, capitalize these annuities. Just to reiterate, Canada will be borrowing enough money to, or issuing, for example, bonds to pay the amount of money due on all of these annuities every year from the interest. So the idea is that Ontario and Quebec are reimbursing Canada for 5% interest on any amount over 62.5 million. And you'll recognize here that it's, when we're looking at these debts, it's not really possible to partition certain things neatly into an excess of debt compared to a total debt. It's just all dollar bills. They're not labeled. So this commitment to capitalize annuities will increase the debt of the province of Canada by a certain amount, but it's not really possible to apportion specific line items to an excess of debt, because Canada, of course, has assumed all of the debts and liabilities. Whatever that final number is, Ontario and Quebec will be paying interest on any amount that exceeds $62.5 million. The capitalized amounts are going to be part of the Consolidated Revenue Fund of the Dominion of Canada. And they will be held in trust accounts for the Robinson Superior and Robinson Huron Treaty beneficiaries. This is how they will be shown in the accounts. And I just also at this point want to note that capitalizing these Robinson Treaty annuities was not a brand new idea. Again, in 1847, the other Upper Canada annuities had essentially been guaranteed by putting them, the annual expenditure for them, partitioned off in what was called the civil list, which was not under the immediate control of the Legislative Assembly. So at the time of the Robinson Treaty the instructions to Robinson, there is an order in council of April 1850, refer to establishing a capital sum that would yield enough interest to pay the annuities at that time, which were the so-called fixed annuities.
And just to lay our eyes on it, can we pull up, please, JB from phase 1, tab 767? Ms. Jones, when we have that up, it would just be helpful if you could identify the text on that document, please.
So we're gonna pull up the document, right?
Yes.
And what is this document, please? Just-
Ms. Jones, can you give us a preview of what the document is that we'll be looking
I'm just
at?
trying to find it on my desk. What are you sending me to?
Oh, we'll be looking at a document that will be pulled up on the screen, and it is from the demonstratives aid that I gave you in the multiple of boxes from phase 1, JB 767.
There, here we are. This is the order in council that sets out at least some instructions for Robinson. This goes back to 1850. So this is before he left on his first trip to visit the future Robinson territories, what we call them today. So if you just scroll down a little bit.
Can we, excuse me, I just need to call this something. Can we call this the OIC that authorizes Robinson to enter treaty negotiations, or is it something else? Council, what do you want to call it?
It was instructions to Robinson with respect to
Yes, I would
Robinson.
say instructions.
Thank you.
As
Jackson.
the evidence would have it in phase 1, there were not just one set of instructions, there were
Yeah.
others. So just to be clear, this is the instructions that are part of trial exhibit phase 1, 1-0767.
Thank you. Yeah, that makes things a little more clear. This is only one part of Robinson's instructions, as has been noted.
And was there a transcribed copy of this?
The transcribed version is at the back of this very exhibit in phase 1. I think if you scroll down, you might find the transcription.
Thank you. That would be much helpful. Can you do that?
Which we can see if our copy that we have.
Oh,
doesn't include
I've
that.
got the phase 1 transcription on my computer.
Next time? Transcriptions.
Ms. Jones can speak to why she prefers these copies and can take us through it. And if it's helpful for your honor, we can get you a transcribed copy.
Right.
Right.
Without having the opportunity to,
Always think of your audience.
yes, well, without having the opportunity to check every transcription, I prefer to go
Yeah.
back to the originals because they will be authoritative. We can look at the highlighted section here. This is informing, this is a reference for Robinson. It says that there is previous text here, but they refer to a capital sum of which the annuities would be the interest. And that the capital sum to which Mr. Robinson should consider himself limited should not exceed £25,000. The interest of which payable as a perpetual annuity would be £1,500. So that to my knowledge was not done. There was not a capitalized amount of £25,000 set aside in the accounts. So this is really just to show the idea that at the time that Robinson was being instructed, the Executive Council of the Province of Canada had considered this as a way of paying the annuities.
My understanding is that there were other things other than annuities, that this was not, that were capitalized.
Right,
This was not a new idea.
right,
When the government was entering into obligations,
right.
it did so in some fiscally responsible way, set aside enough money to generate the funds required to fulfill their obligations.
Right.
Okay, so it wasn't new for the instructions, if I'm remembering correctly from past evidence.
That's
Do I
right.
have it?
That's right.
Okay, thank you.
We can go to slide 47.
I'm just going to ask you, counsel, if you're going to refer often to those 5 volumes, I'm going to ask you to give the registrar an opportunity to hand them out to me. As you might have noticed, I have screens on both sides of my desk, and
Yes.
it's very difficult for me to work from that screen.
Your Honor, in that case, then if you would like to have it handy, maybe the first volume would be helpful to have.
Very good, thank you.
And I can just let you know that we didn't include the entirety of a document there because it would be much larger than it already is. So we just included the extracts that Ms. Jones identified for the purpose of the slide demonstratives.
And what tab did you just take me to?
It would have referred to slide 47.
Slide 47, but what tab was the OIC on?
If you give me one moment.
Yes, please.
Your Honor, if you don't mind, we'll print that item on the break since we're past that slide now anyway. We'll make sure we hand up a copy. It doesn't appear to be in the tabs.
The OIC was not in volume 1?
It may, if it is, we can't see it apparently on the index, so we'll make sure we print a copy if we're not able to identify it.
Okay, thank you.
On slide 47, Ms. Jones.
Right. I'm just waiting for the slide to come up. Here we go. So in December of 1868, Ontario agreed to most of the principles, including the principle on capitalizing Indian annuities, but Ontario did reserve the right of objecting to any and all items of detail, which it may think unjustly charged. I think there should be a D on there, of which the Dominion should keep a minute account. So Ontario did agree to the principle of charging the Upper Canada annuities to the debt of the province of Canada at this time, but reserved its right to make comments on the individual line items within that. So based on the principles, the Auditor General Langton produced a statement of the province of Canada account as of the 30th of June, 1868. And that included an amount for the capitalization of Indian annuities, which in turn included the Robinson Treaty annuities at $88,000, which was included in the debt of the province of Canada. The trust fund accounts of the Robinson Huron and Robinson Superior Treaty beneficiaries as of the 1st of July, 1869, showed credits of $48,000 and $40,000 respectively. So those are in capital trust fund accounts. That's not money that can be taken out and spent. It's intended to generate enough income to pay the annuities every year.
Go to slide 48.
This is just to give you a look at what the accounts look like. So this is a subsidiary statement published in the public accounts of all the things that are going to be capitalized and then added to the Province of Canada debt. And the first thing on the list is the Indian annuities under the civil list. So those are the older treaties that were, annuities were placed in the civil list of 1847. There's an amount there that's sufficient to generate $26,664 a year. And then there's Lower Canada annuities, which, if you recall, after the Robinson Treaty was signed, there was an offsetting amount allocated to Indians generally in Lower Canada. And then Upper Canada annual vote, those are the Robinson Treaty annuities, the fixed sums that are mentioned in the treaty itself, $4,400 a year for both the Robinson and Robinson Huron and Robinson Superior treaties, capitalized at $88,000. The total amount for all of the Indian annuities then that has to be set aside and added to the debt of the Province of Canada is $701,280. And I haven't reproduced the whole statement here, but you can see from the entries that I have reproduced what the rest of the entries look like. They are pensions to individuals for under various special dispensations or grants. And those are capitalized at $298,000. So the total for all of these annuities to be added to the Province of Canada debt is that number $999,835.55, which you will see carried over on several statements after this date. So this is a public account which is published in 1869. It's meant to cover the period, the fiscal year 1867 to 1868. So July 1st, 1867 to June 30th, 1868.
We turn to slide 49.
And this slide is, again, it's an extract. It is the statement that Langton drew up showing the debt of the Province of Canada as of June 30th, 1868. And the point of interest here is on the left-hand side. It's the third item, capitalization of annuities, which is that number $999,835.55. So now you've just seen what goes into that line item and what that amount of money looks like. And we'll be seeing that in several statements going forward. And the total amount of Province of Canada debt, according to this statement of Langton, then was $74,937,000 odd dollars.
So when we see the word annuities on slide 49, it includes all of those annuities on slide 48.
Right, right.
So some are annuities under treaties and
some of them are pensions to individuals. So you'll also see here that Langton has, on the right-hand side, noted the authorized, what he calls the authorized debt under the British North America Act, $62.5 million. Now, this $11 million number, to be honest, I'm not sure how that's generated, because it's not the difference between 62.5 and 74 odd million. So I was trying to trace where that 11 million came from. And again, to be square with you, I'm not quite sure where it comes from. But the point of looking at these statements is more to focus on that capitalization of annuities line to show what's in it, and then how it's added, how it's shown as added to the province of Canada debt in these statements. In any event, it's probably better not to get too deep into some of these total numbers, because they're constantly changing. So this is one statement prepared at one time for a specific purpose. You'll see that the total amount of debt and the value of some of the line items, not so much the capitalization of annuities, but some of the other line items will be changing over time. So it may not really be profitable to get too deep into the specific numbers on these statements yet.
We can turn to slide 50.
I've quoted here an expression from Ontario's treasurer, Mr. Wood, of his frustration on the slowness of progress on the preparation of these accounts and the beginning of the arbitration. He complained in July of 1869, so this is now 2 years after Confederation, that, quote, "we are left to grope our way in the dark, both as regards our annual income and our true financial position." At this point, 2 years after Confederation, he believes that determining the exact amount of the excess of debt prior to the arbitration was, in his words, scarcely tenable. So I think the parties are beginning to understand that even valuing the debts, how much each debt is really going to amount to, is not as straightforward a task as they might have thought prior to Confederation. As I say, these numbers are constantly shifting. So he is proposing to go on with the arbitration before a fixed number for the total debt, which will eventually give them a number for the excess of debt, is just not possible. We can't wait that long. And in fact, the correspondence at this time shows all three governments continuing to add and adjust line items throughout, even while the arbitration was going on. Was what a lot of the discussion was about during the arbitration, was the value of certain debt and asset items, even as much as the allocation, at least as much as the allocation of those items. So Wood's complaining may have had some effect. There was a meeting held shortly afterwards in July of 1869, at which Ontario, Quebec, and Canada agreed to the principles, again, on which the province of Canada account was to be drawn up, including the principle on capitalization and inclusion of Indian annuities in the province of Canada debt. And Ontario and Quebec both drew up their own statements of account, what they believed the account should look like. And they both included the capital amount of the annuities in the province of Canada debt. So they seem to at least agree on that point.
You can turn to slide 51.
So then we have the first meetings in front of the arbitrators, which were held in late August and early September of 1869. And these were attended by a very high level group. The ministers of finance from Ontario, Quebec, and Canada attended with council. And their senior financial bureaucrats, Langton, for example, was also there. And they agreed then early in this process, at the first arbitration meetings, that the debt of the late province of Canada was ascertained with sufficient definiteness to enable the arbitrators to proceed with and conclude the arbitration. So there's a recognition that the number is not yet set or final, but it's set enough that the arbitration, in their view, can go forward. But then the finance minister for the province of Quebec resigned. In fact, he resigned to take a position in the government of Canada cabinet, which was possible at that time because members could be elected and represent their ridings in both the provincial and the Dominion legislature. So Quebec's finance minister resigned from his job in Quebec and took a cabinet post in Canada. So that caused some delay, and the hearings resumed again in February of 1870. There are more adjustments, discussion, adding line items, adjusting line items, to the point where in March of 1870, Ontario and Quebec signed a joint letter to Canada requesting that Canada consult Ontario and Quebec before adding any new items. Their issue was that they would get new statements from Langton that would show new line items, or they would get a letter just from Langton to say, I'm going to add this to the debt. So Ontario and Quebec requested that they be consulted prior to any new items being added to these accounts.
Go to slide 52.
So in February of 1870, then Ontario and Quebec present their arguments before the arbitrators on the specific issue of the claim of Quebec to charge against Ontario the capitalized portion of the Indian annuities. In other words, what Quebec is saying here is that they don't, Quebec doesn't believe that it should have to pay any part of these annuities, that this should be Ontario's responsibility alone. And there's some correspondence in preparation for those arguments in late 1869, where Quebec wrote, the treasurer of Quebec wrote to Canada and to Ontario requesting information on, quote, the Indian reserve lands transferred to the Crown Land Department, the quantity sold and the price. So the treasurer of Quebec at this point is not tipping his hand as to why he wants this information, but it is going to be part of their preparation for these arguments. So he gets replies from Ontario and from Quebec. Ontario replies that records relating to, quote, Indian reserve lands, end quote, have been kept by the Indian Department and were now held by Canada. Then I've condensed this somewhat in the slide, but the treasurer of Quebec writes back to say, that's not what I meant. I meant all of the ceded Indian lands in your province. To which Wood, the treasurer of Ontario, then replies that the ceded Indian lands had been sold to generate revenue for the province of Canada as a whole, including expenditures that had only benefited Quebec. So essentially, the reply of the Treasurer of Ontario is that the money from the lands that have been sold in Ontario benefited both Upper and Lower Canada. And to unravel all those financial transactions, all the sales and all the expenditures in both halves of the old province would probably be impossible, and in his opinion would probably show that Quebec had benefited substantially from the sales of lands in Ontario. Canada also replies to the Treasurer of Quebec and notes that they do supply statements of the lands ceded under the treaties, the amount of the annuities, and the amount of land ceded, and the amount of Indian Reserve land. But also there's a note on their statement observing that Canada had assumed the annuity payments promised by the imperial government under these treaties, but that the lands were the property and the public lands of the province of Ontario. And I believe we have that extract.
Yes, that's tab JBD tab 2790. And if we go to image 16, and for your honor, in your compendium, that's tab 55. It should be in that volume you have in front of you.
Volume 1. Yeah.
Tab 55 of volume 1. Or volume 2.
Volume 2, perhaps?
Yes.
Thank you. So are the tabs numbered all the way through?
Yeah, the documents that you have are in order as they appear in the demonstratives. And they're the tab numbers of the compendium don't necessarily align, of course, with the JBD tab numbers.
No, my question was, do the tabs in the 5-volume set continue sequentially all the way through
Yes.
the 5 volumes?
Yes.
Thank you. Okay.
We want to have image 16. Ms.
Right.
Jones, you just said
Right.
that there would be a reflection of what you had just described as
Right.
the response.
Actually, if we can just briefly go to the previous page of this document. This is a statement which was attached to Canada's response to Quebec. And as you can see, it gives the amount of the annuities paid and the tracts of land surrendered under each of the treaties in Upper Canada. Just scroll down a little bit. And a little bit further. And then a little more. That's just to show you what the table looks like. And then not included in the table, but written in below it is reference to what is called the new annuities under the Robinson Treaty. And it shows there the amounts paid annually to the tribes on Lake Huron and on Lake Superior.
Is it, I'm sorry, but did you give me a page, how to find the page in tab 55?
So you have the extracts referenced in the slide deck, 9 to 16. So the table that we're looking at now will be within that extract. On the last page.
Last page. Thank you.
So there is some explanation of this table which is included below the table. Actually, keep there, that's good right there. You explain the notations in the table that the cessions to the Crown in consideration of which the within named annuities are paid comprehend chiefly the old settled district of Upper Canada, whereon the greater part of the lands have many years since either passed into patents or the lands have been sold. There's some reference here on outstanding, possibly unsaleable land. And then there's a specific reference to the lands on Lakes Huron and Superior, which are described as being chiefly valuable for minerals. Now, I should say at this point, who is writing these? This is signed WS, which is William Spragg. He is the Deputy Superintendent General of Indian Affairs at this time. So the notes that we're reading on the screen now are his observations elucidating the information in the table. He goes on to say, as respects the general question of the annuities, it should be borne in mind that the Government of Canada entered into engagements with the Imperial Government under which it assumed and guaranteed the payments. I think he may be referring as far back as 1835 here, when, if you recall, the government of Upper Canada, as it was at that time, undertook to pay the annuities for these treaties out of what were called the territorial revenues. But the expectation of the imperial government was that the payments would continue to be made, even though they were not coming out of the imperial treasury. So he describes this as an engagement with the imperial government under which it assumed and guaranteed the payment. And that the Government of Canada, it's not perfectly clear whether he means the province of Canada or the New Dominion, but he may even mean both at this stage. The lands referred to in this memorandum, which remain unsold, are the property of the province of Ontario and are at the disposal of the government of that province. And the lands which have been sold or granted have been so sold or granted as public lands. So here Spragg is setting out his understanding of a separation between the annuities and the lands in the province of Ontario. One of the annuities come under the engagements of the imperial government, which it assumed, and the lands passed to the province of Ontario. So recall again that Spragg was the one of the most senior administrative officials in the Department of Crown Lands for the province of Canada. He then became the first Deputy Superintendent General of the province of Canada of Indian Affairs. And he is now the Deputy Superintendent General of Indian Affairs in the new government of the Dominion. So he's setting out here his understanding of what these arrangements mean.
And his understanding, I'm just looking at your use of the word it, his understanding is that the engagement of the imperial government passed to the Dominion,
Yes.
because you said which it assumed. That's the, you said
Yes,
that's the Dominion.
he
and
says, he uses
whereas
the
lands
term,
passed to the province.
he uses the term government of Canada here.
Okay,
So he doesn't say the province, he refers to the government of Canada.
We move on to slide 53.
We don't have a verbatim transcript of the arguments before the arbitrators. We have some notes in the record of proceedings, which we do have, but some of the descriptions are quite general. We also have some printed statements of the arguments of the parties before the arbitrators. And from this, I can say that Ontario repeated some of its statements or all of its statements that it had already made to Quebec in its arguments before the arbitrators. Noting, for example, that the lands ceded by the Indians in Upper Canada were afterwards sold, and the monies received from their sale went in the general revenue. I'm quoting now from Ontario's written reply to Quebec's case, which I think is cited at the joint book tab at the bottom there. It's in my report at page 58. And also referring to a vote of lands and annuities to Indians in Lower Canada that were made as an offset to the Robinson Treaty lands and annuity payments. Although the primary argument in the written statement is that the money received from the sale of lands in Upper Canada was an amount that would have created a capital fund that would have paid 10 times the amount of these annuities. And that this money would have, the money from land sales benefited Lower Canada at least as much as it benefited Upper Canada. That's the argument I'm referring to on this slide. And Quebec argued that the annuities were a trust on the land under section 109 and should be charged to Ontario alone rather than to the United Province. Canada didn't make arguments before the arbitrators at this particular set of hearings because its position was that the arbitration was intended to decide apportionment between Ontario and Quebec, and it did not have an interest in the proceedings or the outcome.
Thank you. Ms. Glasser, can you tell me if the evidence you foresee going in on the arbitrations takes any issue with the evidence that we have received on the arbitrations?
There is some context that Ms. Jones is providing that hasn't been heard to some extent. So of course the decisions are what they are, but the surrounding circumstances, which she'll be providing more detail about.
Okay, well, I'm going to ask you, Ms. Jones and Ms. Glasser, if you wouldn't mind to point out where, if at all, you differ from the evidence. And just let me give you some context. I'm doing my best to absorb the evidence on the arbitrations. We have a body of evidence on the arbitrations. If there is a difference, I don't want to be in the position where I'm combing through and looking for it. I would like you with much sharper eyes and familiarity with the material to do that. And if there is no issue, I wouldn't mind you pointing out that as well. Because if I'm getting from two people a body of evidence that is the same, but maybe some difference somewhere, you're handing me a big task.
I think, Your Honor, in the next two slides where we will be getting to the issues that are different, and we can highlight those for you through the questions, if that's okay.
That would be very good. And where you get to more material, if there is no difference,
Sure.
you either tell me there is none and pass it over.
Sure.
Okay. Thank you.
Right, I'll just, you know, I may not be completely familiar with all of the evidence that all of the other experts have provided.
Not all of the other.
I
right,
don't-
There's just one on the arbitrations,
I,
happily.
so I may not, I may not catch what all of the
Yes, that's
differences
fair.
are.
But
Yeah.
I'm sure Council for Ontario knows what she's trying to elicit, and
Right.
I am very interested in you bringing it to my attention so that I do not miss it.
I will do that.
Thank you.
So I just want to, of course, I think this, this has been mentioned before, that the written arguments
That's
do
what I'm
not,
saying. It's sounding very familiar.
yeah, okay. Do not indicate that any party raised the possibility of an increase or that an investigation was undertaken to determine if an increase was warranted in the Robinson Treaty annuities at this time.
We're going to slide 54.
After hearing the argument about the annuities, Ontario and Quebec Council then moved on to present the arguments on really the central issue of the arbitration, which was the principle and mode of the apportionment of the excess of debt and the division of the assets. Ontario produces 3 alternatives, which end with broadly similar proportions. But the method proposed by Quebec produced a result which was much more advantageous to Quebec. About 80-20 between Ontario part of the debt and Quebec's part of the debt. So there is a big difference between the methods proposed by the 2 provinces. On the 28th of May, the Board of Arbitration split. The arbitrators appointed by Canada and Ontario issue a draft judgment or award on a proposed method of apportioning the responsibility for the debt. So here there's no even numerical proportion suggested. It's only a method on how a proportion might be ascertained or how debts might be divided.
Ms. Jones, just for responding to Her Honor's question a moment ago, is this a point of difference from yours and Ms. Mesamore's or Professor Mesamore's report in terms of the result from the arbitrators?
Yes,
Can you please describe the differences?
I make it clear in my report that this is only a draft. This is not a final award. It does not apportion any assets. It does not set a proportion. It is only a proposed methodology. The proposed methodology is based on one of Ontario's proposals. It seems to start with the assets in the 4th schedule of the British North America Act, which it was under section 142 was one of the tasks of the arbitrators to divide the assets in the 4th schedule, to determine the origin of the debts incurred by the creation of those assets. And then if there were any debts left over that didn't leave an asset, to deal with those separately. And possibly based on that division, again, it's only very generally sketched out in this draft award. So it's hard to determine exactly what they were thinking of. But the allocation based on this methodology that they're proposing seems to have been this, that they start with the assets in the 4th schedule, what debt was incurred to create those assets, and then if there are debts that don't leave behind an asset, what are the origin of those debts as between Upper and Lower Canada?
We turn to slide
Can,
50.
so the beginning of this question to Ms. Jones was, is on this topic, is this where you have a difference with Professor Messamore and you say yes? And what is your difference?
I think she describes this award as the final or the only award. And the determinative award is going to be coming later on the 3rd of September, 1870.
Which has been called the 1870 award?
Right. That's over the,
So you say the final award is the 1870 award,
Right, 3rd of September.
3rd of September.
This is only a draft, which I think we have on the next slide. We have some more.
So how can I
Context.
distinguish it? Because on slide 54, you call this one an 1870 award.
Your Honor, if the second bullet identifies May 28th, 1870 as and that's the draft award that Ms. Jones is speaking of. And the following slide, which if you go to slide 55,
So
it
I
describes. it.
want to say that on slide 54, we are looking at the draft dated May 1870. And you say that that the difference between you and Professor Messamore is that the May 1870 decision is a draft
Right,
and the final is September 1870.
that's correct.
Thank you.
If you turn to slide 55, the first bullet reflects that point, Your Honor, about the May the May decision being a not final decision.
Right. So the arbitrator appointed by the Dominion attempted to facilitate an agreement between the arbitrators for Ontario and Quebec. He issues a written opinion in the 8th of July that emphasizes, quote, that the decision of the 28th May last is not final. It is only an opinion of the majority as to the best mode to proceed in the division. If in working it out, it is found to operate unfairly, it is open to be reviewed and rescinded. It is a mere mode of inquiry and open to correction. But at that point, Quebec's arbitrator resigns and Quebec Council refused to participate any further, which actions were endorsed by an order in council of the province of Quebec. But the rest of the board continued to meet to hear the arguments of Ontario.
We can turn to slide 56.
So here we have the final award, 3rd of September, 1870, which is referred to as the 1870 award or the award of the 3rd of September, 1870. So the award did not give a total amount for the debt of the province of Canada. And it therefore does not state what amount over the debt allowance is going to be attributable to Ontario and Quebec. It only sets out a proportion. So this is a recognition that the process of ascertaining the outstanding debt is still underway. It's not possible to set final numbers at this stage. But the proportion given in the award will determine eventually on how much Ontario and Quebec will be paying 5% interest to Canada by means of a deduction from their subsidies. So in order to establish the proportion, the board used one of the methodologies put forward by Ontario, which I think is slightly different from the one used for the draft award.
Now, in your report, Ms. Jones, I'm highlighting for the judge. I think this is another area of difference between yourself and Professor Messamore that you've also reflected in your report. There was a discussion about the contributions to Lower Canada with respect to the annuities and 230,000 acres of land being a set off. Can you help us understand how, if at all, that resulted in the or contributed to the decision in September of 1870?
I think there is, Professor Messamore pointed out, and I pointed out as well, that there is an offset, as was the custom in the province of Canada at the time. If an amount of money is spent in one part of the province of Canada, Upper or Lower Canada, then the other part of the province would expect some roughly similar expenditure. So there was land and money set aside for Lower Canada in 1851 after the Robinson Treaties had been signed. That was supposed to be roughly equivalent. But to me, the arguments of Ontario emphasize much more that the total revenue from sales of ceded land, again, this is mostly not in the Robinson Treaty area, it's the lands that are further south in Ontario.
The ones that would have made up the civil list
Right,
annuities?
right.
Okay,
That the value of those land sales, that all of the revenue went into the joint treasury of the province of Canada. And also recall at that time that most of the best lands in Lower Canada had already been sold or allocated long ago. So it is the land sales in Upper Canada that are generating more revenue for the province of Canada rather than land sales in Lower Canada. So, and then land sales is a smaller proportion of the revenue than, say, customs revenue. But it is still a contribution to the total treasury of the province of Canada. Ontario's argument is that the value of all of those land sales and the benefit from Lower Canada from all of that revenue is not just the offset of the acreage and the dollars that were set aside for Lower Canada Indians in 1851, that it's much larger than that.
Ms. Jones, if I may, just to assist Her Honor, you referred to a Messamore document in this argument that Ontario is making, and if it would assist the court, we believe it's the document at JB 1754. If we can, that was the Messamore document that we believe you're referring to.
is it one of the tabs in this
No,
set?
because it's responsive. We're narrowing it for your benefit and referred to Ms. Jones just now.
You don't have to explain why, I just want to know if I should look for it.
Oh, sure. It's not in the compendium for that reason.
Now, I have referred to a written reply to Quebec's case, which is on page 58 of my report, that reference. We also have this document, which is in the Irving papers. The particular file in which it's located, and just the Irving papers in general, but the particular file that this typescript document comes from contains a lot of, I guess you could say, miscellaneous materials collected by Irving that he thought would be relevant to Robinson Treaty arguments in the 1890s. So this document doesn't have a date or a provenance, which makes it a little bit of a challenge. But on reading the content, it seems to me that it parallels Ontario's arguments, the written argument in the 1870 arbitration. And also there are no references in this document to anything after 1870, which
Excuse me, could you give this document a name?
let's call it New Indian Annuities
But without an author.
without an author.
Okay.
So I'm just going through my process here as to how I've tried to identify what this document is, because it doesn't have an author and it doesn't have a date. And if you go to the very bottom, the end of the document on page 5.
And just to be
Oh,
clear, just to-
No, it's the end of the TypeScript document, I'm sorry, which I think is page 3.
Ms. Jones, just before we go on, just to clarify, this was a document that was referred by Ms. Mesamore.
Yes.
Professor Mesamore, my apologies, and identified with respect to these arbitrations in 1870.
I don't know whether she identifies it with 1870, but my feeling is that it probably pertains to 1870 rather than the 1890s.
Was it identified by Professor Messmore?
Yes,
Is it an exhibit in her material?
it's referenced as a JB document, so it would be in the exhibited JBD. The reason why Ms. Jones can explain for herself, but the reason why we pulled it up is because it was responsive to the setting off statement by Professor Mesamore that Ms. Jones is distinguishing as between her and herself in terms of emphasis.
Yeah, you'll have to, maybe if you can start by telling me what the difference is so that I can
Okay,
understand where you're going with the evidence, because so far
all right.
on this, I'm pretty lost.
I was, right. Well, trying to identify the document is always one of the first stages. What is it? It doesn't have a name. It doesn't have a date. What could it be? Where did it come from? I believe that Professor Messamore referred to a statement on the first page of this document. If we could see that. About the offsetting payments and set aside of land to Indians in Lower Canada as a set off to the payment made to Upper Canada Indians, et cetera. And if you go down a little further, and on to over to the next page. This is obviously meant as a reply to arguments of Quebec. It is in this document, it says it's difficult to, if you could just scroll up a little bit more. Thank you. It is therefore difficult to conceive on what ground Quebec can urge before the arbitrators any claim against Ontario on account of Indian annuities, new or old. And then the argument continues that in fact, Ontario lost by this offset to Upper Canada because there could be no revenue from the land sales of land set aside, as well as the dollar value granted by the legislation. But then if you go down further, you see that, so Ontario doesn't engage with this offset. And I think that's something that Professor Messamore emphasized. But then, okay, stop. Down a little, can you scroll up a little further? The sentence that seems to me to be more congruent with a more important part of Ontario's argument before the 1870 arbitrators is that the sentence that begins, in the case of the money paid and the annuity under the Robinson Treaty, United Canada before Confederation received both money and annuity back more than 50 times told, in the advantages of which Lower Canada participated equally with Upper Canada. So the argument here is that yes, there is an offset, and that actually cost Ontario money. But more importantly than that, and much more the value of any of these payments, is the value of all of the land sales that of land that was ceded under treaties in Southern Ontario. So that would be the part that I would emphasize and that I have emphasized in my report about Ontario's arguments regarding the effect of the offset. And I think Ontario is consistent in that argument up through to the 1890s.
What is the difference? Could you remind me what Professor Messamore says that you say differently or you emphasize differently?
I don't know whether I want to try to paraphrase what she said.
I can use a term that I believe was part of the evidence. It was the quid pro quo of the contributions to Lower Canada that she highlighted as being important to the proportion determined by the arbitrators in 1870. And Ms. Jones is explaining, as I understand it, and she can correct me if I'm wrong, the distinction between her understanding of the payments to Lower Canada and whether they were truly a quid pro quo that impacted the proportion determined by the arbitrators.
My characterization is that Ontario's argument is much broader than that of the offset or the quid pro quo, that that is part of Ontario's arguments at this time, but that the much greater context is the value of all of the lands that were sold in Southern Ontario that were ceded by the Indians, in which Lower Canada participated equally.
We can go back to slide 57 now. This time? Okay, Your Honor, I understand that it'd be a good time for a break.
Thank you.
A 15-minute break, I understand.
Just let me catch up for 1 second. And the document that we have just put before us is from the joint book of Phase 1, Exhibit 1-1754. Is that correct?
It's a phase 3 document,
Ah,
JB 1754.
Thank
And
you.
if I could, I think another difference between myself and Professor Messamore is that she attributes this to Irving as part of the arguments made in the 1890s.
Mhm.
I think it is more likely an extract of something that he found or that was forwarded to him from Ontario's arguments before the 1870 arbitrators. Because it seems to parallel those 1870 arguments much more closely than it does the arguments that were made in the 1890s. So I think it is a retyped extract of something that was available to him that we don't now have anywhere else from 1870.
When you say it is a retype, this,
The new
Document we're
Indian
looking at.
annuities document. And I might say there are many things in the Irving papers related to these arbitrations that we don't have anywhere else. That he was a great collector and researcher, and his files are full of items that are relevant to many claims in Ontario.
thank you. Okay, we'll take the break, 15. Thank you.
All right. Let's go recess for 15 minutes. When I was in, you may be seated.
Ms. Jones, before the break, we were going over some of the differences between yourself and Professor Messamore regarding the understanding of the 1870 arbitration. And we're now at slide 57 of your demonstratives. And I wondered if you could highlight for us briefly the outcome of the final award and any important points you want us to be cognizant of.
So the methodology on the face of this award of 3rd September is not at all transparent. It took me a little while to try to figure it out. The award itself only refers to certain numbers which set a proportion. It's not clear on the face of it where the numbers come from. But I believe it parallels a method which was proposed by the Government of Ontario, which is to, first of all, decide what debts could be considered to have their origin in either Upper or Lower Canada for what might be termed local purposes. For example, municipal loan funds, that's a pretty easy one because those funds were meant to, as I say, facilitate borrowing by small municipalities that otherwise wouldn't have enough credit to borrow for things like town roads or other public infrastructure.
And on this point, you agree with Professor Messmore that this is what the award says. If it has a local, if the debt had a local origin, so the debt should be applied to that province.
Well, the methodology of the award is a little different. First of all, the arbitrators decided what debts could be assigned to any local purpose, Upper or Lower Canada. They found, again, that many of the largest debt line items didn't leave behind an asset. So I think that they kind of abandoned the idea of using the assets in the 4th schedule as a guideline for how to partition the debt. They just took the debts, the arbitrators took any debt that they thought could have a local purpose and put it into, say, a big bin, which was worth $18,587,000, $520.57. And then in that big bin, the arbitrators identified debts that would pertain to either Ontario or Quebec, again, for these local purposes. And another issue here is that $18 million number doesn't correspond to anything like an excess of debt number, which was thought to be about 10 million. So Galt's initial explanations of why the province of Canada would have to pay interest on an excess of debt, in that there were expenditures for local purposes and expenditures that could be considered central or national, didn't really work out in the practice of it, because the things that the arbitrators identified as pertaining to local purposes were much bigger than anything than any excess of debt number that they'd come up with. So once the arbitrators had partitioned this local origin or for local purposes debt to Ontario and Quebec, then there were two numbers, 9.8 million and 8.778 million. And that set the proportion for which, when the debt was ascertained, how much would the excess would be on which Ontario would pay 5% and how much on which Quebec would pay 5%. So the award itself doesn't establish these numbers, although there are numbers in it. It doesn't set a final amount for either the total debt or the excess of debt, but it establishes a proportion. At that time, the debt over $62.5 million was estimated at about 10.6 million. So the Canada would then charge 5% on those amounts as allocated by the arbitrators. And I think we have an example of that coming up, how it looked in the accounts.
Yes, just to be clear, for Her Honor, the excess of debt that you referred to, 10.6 million, is not reflective of the amount analyzed by the arbitrators to determine the apportionment.
That's right. You know, essentially 62.5 is a fairly arbitrary number. Again, I think it was part of the negotiations at Confederation where Nova Scotia and New Brunswick would come into the Confederation with, as all the other provinces, all of their debts assumed by the new Dominion, but they would also get a little bit of money back on their subsidies if a debt was set at that number. But the province of Canada would have to pay a little bit. I think that was to reassure Nova Scotia and New Brunswick that they were not paying for the past behavior of province of Canada. And internally to the province of Canada, Galt has said, no, this is fair because this part of the debt we might have incurred for our own local purposes. Now, as it turns out in the arbitration award, you can see that Galt's approximation of what that local expenditure might be is not very close to what it turned out to be when the arbitrators looked at it in their view. So again, I think that the idea of the debt allowances is shouldn't necessarily be looked at as a kind of a scientific measurement. It should be looked at in the context of a set of political negotiations.
Set of political compromises.
Yes,
Turn to slide 58. This is the example you're referring to?
yes.
So I'm going to hold that theme. And if you stick to themes, I don't know that I need an example of that
Okay,
because the purpose of this evidence is to get to a bigger picture.
all right.
So I'm going to accept that theme, particularly since it is in accordance with the theme that we have had before. Council, can you
Sure.
go with that?
Yeah, and Your Honor, just so you know what the image is, this was just a reflection of the apportionment.
It's just to show what it looked like in the books.
Thank you.
Right.
We'll go to slide 59 then. You can take us through this briefly.
Yes. So this is the part of the award that deals with Indian lands and treaties annuities, which I'm sure you've seen before. That lands in either Ontario and Quebec, surrendered by the Indians in consideration of annuities. And I should say that that paragraph really only applies to the province of Ontario. Shall be the absolute property of the province in which the lands are respectively situate, free from any further claim upon or charge to by any other of the said provinces. So it's just meant to cover, and this is all this arbitration was ever meant to cover, claims of the provinces, one against the other.
Thank you.
Slide 60.
Quebec immediately challenged the validity of the award on a number of bases. The procedural issues that its arbitrator had resigned, that it had not been represented after the resignation of its arbitrator by council or by their ministers of finance. And that the award itself was unjust. But Canada did not intervene to either enforce the implementation of the award or declare it invalid. It went to the Judicial Committee of the Privy Council based purely on procedural grounds, not on the content of the awards, which in 1878 ruled that the award was valid. So now we get into, while all of this is going on, in 1873, after Manitoba, the Northwest Territories, British Columbia, and Prince Edward Island had joined, and there was discussion about financial arrangements again, Canada acceded to pressure from Quebec to increase the debt allowance for the old province of Canada to the amount of the debt as calculated in a statement published in the public accounts. So it's a very specific number. It comes from the public accounts. The wording of the legislation is not to completely remove all the debt. It's just to a specific number.
For Her Honor's benefit, I just want to confirm that the JCPC confirmation of the validity of the September 1870 award as opposed to May 1870 is at your compendium tab 66.
Thank you.
Ms.
The
Jones.
5-volume compendium.
Yes.
Thank
the
you.
First volume. Ms. Jones, with respect to the debt increase, we've heard a lot about the impact to the excess debt, but can you let us know briefly about how it impacted the subsidies for the provinces?
It meant that the interest that the Ontario and Quebec had deducted from their subsidies was greatly reduced. There was, if you look at the accounts that were drawn up later, there still is a small amount being deducted because there is still a little bit of residual debt, but the essentially the subsidies were being paid without the fairly large deductions that were made previously.
Okay, slide 61.
And that, again, it's just to show what 1873 looked like in the account. You can see there's a big credit. June 30th, January 1st, 1873. And that is the credited amount of the amount listed in that in the public accounts of the previous year. You can also see, just to get an idea of how much Ontario and Quebec were having deducted from their subsidies. In 1872, for example, you can see the interest is deducted, 136,000 for Ontario, 121,000 for Quebec. So it's a material number. It would be something that would have made a difference to the provinces to have that amount of money deducted from their subsidies.
Okay, we're going to go to slide 62, which is now a different topic, which is augmentation of the Robinson Treaty annuities from 1871 to 1874.
Right. So again, we've heard a lot about the augmentation. I'm going to focus in this particular set of slides just on the relationship between Ontario, Canada, and Canada. There have been petitions from Robinson Treaty beneficiaries requesting an augmentation. I have referred to this one in 1871. In fact, the covering letter that was received in 1871, the covering letter for that petition from the Indian agent referred to the fact that the Robinson Treaty beneficiaries in his area had repeatedly brought forward to him inquiries about a possible increase in their annuity.
That's your,
So
sorry to
yeah.
interrupt, that's JB tab 2808. And in your honors compendium, that's tab 69 in the first volume.
Thank you. So we see in later correspondence, for example, some discussion of when these claims were first brought forward. There is one in 1871, which seems to be forgotten later. There's reference to the petition of 1873 as being the first claim. But in fact, I think what we're seeing in the written record is very much a filtered sample. I think from the letter from the Indian agent in 1871, it's clear that Robinson Treaty beneficiaries were actually bringing forward their claims much earlier than is recorded in the government documents.
All right. Moving on to your next bullet.
In both of these instances in 1871 and 1873, Canada notified Ontario that it had received these requests and asked that Ontario consider them and take action as Ontario deemed appropriate. It's a very open-ended request. It's not a specific request at this time. Then in 1874, we have a number of changes by 1874. There was a new Liberal government, which had been elected to replace the former Conservative government. The Deputy Superintendent General, a very long-standing, Mr. Sprague, had died in office and had been replaced by Lawrence Van Cunit, who had also served in the Crown Lands Department of the Province of Canada. And we have a new minister responsible. We have a new Superintendent General of Indian Affairs. So that new cabinet, new minister, new Deputy Superintendent General, prepare and send another order in council to Ontario in 1874, requesting that Ontario enable the Dominion government to make such increase in the annuity thereby secured to the Indians as they may be thought entitled to. So again, it's a very open-ended request.
Before we go to the next slide, I wanted to know if we could focus a bit on what information was in the documents shared with Canada regarding the petitions and what was shared with Ontario and any discrepancies between them. So perhaps we can look at document 2817. Can you tell us what this document is, please, Ms. Jones?
This is a covering letter for, there were actually two petitions in 1873 from Fort William, the chiefs of the Indians of Lake Superior. And this is written by a man named Dawson, who was a surveyor, a member of parliament for this area. And he was quite familiar with the Indigenous people of the North Shores of especially Lake Superior and west to Lake of the Woods. And in forwarding this petition, he describes it a little and gives some of his analysis of it. And he specifically refers to the possibility not only of an increase to $4, which I think is what the petitions themselves refer to, but an increase over and above $4.
If we go to image 3.
Yes.
Can you just read the text that's highlighted, just given the handwritten script there?
All right. Right. In
Sorry,
Dawson,
my friend is using words like, can you read the document there? Perhaps a little more specificity for the record.
I've referred to image 3 on the record
Image 3,
of the PDF.
for the record, what is image 3?
Image 3 of 10 of the document on the screen at JBD 2817. It's the bottom half of the page 3.
so in Dawson's view, since 1858, he says the lands ceded have become sufficiently productive to warrant the increased payment of at least $4, if not of such further sum over and above the $4 as, moving on to the next image, Her Majesty may be graciously pleased to order as provided for in the above cited clause of the treaty. And then Dawson points out that there's a difficulty in that the government of the Dominion of Canada no longer has access to the information about revenues from the territories, that's in the hands of the province of Ontario. So this is something that Dawson particularly draws the attention of the Indian Affairs Administration to, with regard to this petition. Don't just read it as far as $4 goes, but know that there is an additional sum which is provided under the treaty.
And who was
And-
the recipient for Canada that then reviewed this memo?
This is addressed, if we can go to the first page. If we could, can we go down to the bottom? This is addressed to the Secretary, to the Governor General, who then passed it on to the Indian Affairs Administration. It made its way through the bureaucracy to end up in the Indian Affairs Administration.
So you refer to document 2691, JB 2691, and that's tab 70 of Your Honor's Compendium Volume 1.
Can you tell me what exhibit 90 is?
This may be the 5-volume compendium that was marked at the outset of the hearing on Monday.
Is it? Because it's compendium of arbitration documents.
Pertaining to the demonstratives?
No. So it's just, I'm very worried that you use the word compendium alone, and like I've
Sure.
said, I'm going to be all alone in a room.
Sure. So far, I've only been referring to the compendium of documents to aid Ms. Jones's demonstratives and not the other compendium of arbitration documents.
Even though we were talking about the arbitration.
Yes,
So you can understand
I
how I
understand
might be
your point.
confused.
yes.
So I would like you, if you don't mind, when you talk about tabs of the compendium to the demonstratives, talk about the 5-volume set.
I will.
That would help me. So your comment, Ms. Jones, was the Dawson letter was addressed to the Governor General, made its way through the bureaucracy to Indian Affairs.
Yes.
Thank you.
So we pull up 2691 of the JVD, which is tab 70 of the 5-volume compendium to aid the demonstratives. Can you explain for us, Ms. Jones, what this document is?
This is a document which was in the files of the Lieutenant Governor's Office, Province of Ontario. That's what the wrapper indicates. And what this is going to be, if we can go on to the next page of it, is an order in council, a Canada order in council. So this is how governments would communicate officially at this time, was through the issuance of orders in council. This is a Canada order in council dated the 9th of July, 1873. And it requests Ontario to consider, if you could scroll down. Yeah, to consider the annexed petition, I believe it says, if you can go to the previous page.
Is this one of the tabs?
Yes, this one is tab 70 of your volume 1 of the compendium to arbitration documents.
Didn't I just see on the screen an order in council?
Yes,
Yes.
And so I have
Any particular page or?
We were going to be going, she was just walking us through the document, but we'd be looking at page 4. Or image, we're starting at image 3. This would be page 3 for you as well.
Of this tab, when I get to page 3, I have a signature page, certified somebody Hemsworth,
Hemsworth, who's the clerk of the Privy Council.
and
at this
that's what
time.
you're directing me to?
I think we should go to the previous page. Right. So this is a notification that in the Order in Council that Canada has received a complaint made by the Indians of Lakes Huron and Superior. Scroll down a little. Who were parties to the treaties. Regarding the sale of considerable quantities of land, no augmentation of the annuity specified in the treaty has taken place. And this is a recommendation by the Privy Council that the facts of the treaty and claims now put forward by the Indians and the grounds thereof be made the subject of a communication to the government of Ontario, and that next page. That government be moved to take such steps in the matter as under the circumstances may seem to them to be just on the part of the province of Ontario. Then if we go on to the next page, this is the communication now.
And what is this document?
This is a memorandum which is attached
Authored
to
by
the
whom?
Order in Council. So this is the information that Ontario would have received at this time. It is actually an abridgment of a longer memorandum written by the Deputy Superintendent General, who is still Mr. Sprague in 1873, about what he calls the facts connected with the treaties. And in this particular document, Sprague spends more time on the potential population that might be paid an increased annuity, presents his argument that it should be limited to the numbers mentioned in the treaty, but doesn't make a particular recommendation as to how much money should be paid. If you can scroll down a little. He does quote the clause about £1 provincial currency in any 1 year, or such further sum as Her Majesty may be graciously pleased to order. And then if you can scroll on to the next page. He then begins to discuss he discusses fulfillment of the above quoted stipulation to the extent of $4 annuity per capita. But what was not attached to this Order in Council was Dawson's letter emphasizing that it is not just $4, but it should be read as a promise of more than $4 if it were possible to pay that. So Ontario does not have that letter from Dawson in which he draws attention to that clause.
Are you aware of it ever coming to Ontario's attention?
No, I don't believe it was ever sent to Ontario.
Dawson's letter.
That's right. Because that was just sent to the Secretary for the Governor General. So we don't see that it was ever sent to Ontario.
We go back to the slide deck, please, slide 63. So we're continuing with the theme of augmentation of the Robinson treaties after that exchange regarding the petitions.
Right. So in October of 1874, this is after Ontario has received another order in council from, so this is the third one now that Canada has sent. There was one sent in 1874. And Ontario, the Oliver Mowat, the Premier and the Attorney General, prepares a memorandum to the Cabinet, Ontario Cabinet, communicating Ontario's response to Canada's representations. And just to remind us, Mowat had been a delegate from the province of Canada to the Quebec Conference. Shortly after that, he was appointed as a judge and then appointed or made straight from the bench in 1872, the Premier and Attorney General of Ontario, which is something we don't see in the modern era, but which was apparently possible at that time.
Can I just clarify for the record, the Canada conference you're referring to is of what year?
The Quebec Conference,
Sure.
1864. So he was a delegate from the province of Canada and in fact sponsored or put forward, I guess you could say, for the consideration of the Assembly, some of the resolutions on the divisions of power between the proposed central government and what were then called the local governments. So in this memorandum to Cabinet, Mowat sets out his views on this particular issue of payment of annuities under the Robinson treaties and increased annuities in relation to the British North America Act and the 1873 legislation. In Mowat's views, the Dominion assumed the debts and liabilities of each province existing at the time of the Union, except so far as the general language of Section 111 is controlled by Section 109, which subjects the property of every province existing in respect thereof and to any other interests other than that of the province. It's Mowat's view that the lands now in question were not subject to any trust legally. They were the property of the Crown before the surrender or the treaty, he's saying. The so-called title of the Indian was one of courtesy only and was by the treaties extinguished absolutely. We go on to the next slide.
64.
We have more of Mowat's opinion. In his view then, he says that it's not contemplated that the annuities should be a lien on the lands. The liability for the amount of the annuities being assumed as a charge upon the entire revenue of the province. So again, he's pointing out that this was not a payment that came out of Upper Canada's revenues. It was the revenues of the entire province of Canada. And then he says, besides, the policy of the BNA Act was to place all matters relating to the Indians under the exclusive authority of the Dominion Parliament and government. And he shadows a little bit of the language from 1837 that we saw in this next clause. Not to leave the rights of these people to depend on or to be dealt with by provincial authorities.
Just to be clear, when Mowat says the liability should be assumed as a charge upon the entire revenue of the province, he's talking about the UPC.
Yes.
Thank you.
And then he goes on further to say that the question of the liability of the province of Ontario in respect of the Indian annuities was fully discussed by the respective council for the province of Ontario and Quebec before the arbitrators. So before the 1870 arbitrators, we've seen that there were arguments presented and there was, as part of the 3rd of September award, an opinion expressed by the arbitrators. In his view, that award and the arguments that were advanced by Ontario at that time established conclusively that this province is not liable to be charged with the Indian annuities.
Slide 65.
I have a question. When you say he shadows the language of the 1873 legislation,
It's 1837. that
sorry,
I'm thinking of,
1837
yeah.
legislation, that is the capitalization.
What I'm thinking of is the
The
recommend-
the reason for the capitalization, that the money be safeguarded? Or not at the mercy
what
of
I
the
was going to
legislature?
draw a parallel to was the 1837 paragraph from the Imperial Committee on Indigenous Peoples in the colonies.
Forgive
where-
me if I didn't jump to that.
where the recommendation of that committee was that the administration of local lands should be separated
Right.
from the responsibility for Indigenous peoples.
Thank you.
It seems to me in that little paragraph that I quoted there that he is echoing some of that idea.
Thank you.
However, Mowat goes on to say that he has received information from the Crown Lands Department to say that in his view, shortly put, that there is enough revenue that has been received to entitle the Indians to the increased annuities which they claim. So he's accepting that under the treaty, the Robinson Treaty beneficiaries have a valid claim to an increased annuity. And proposes that the issue of who should pay should be submitted to a court determination. He proposes also that the Dominion government could settle with the Indians without prejudice to any question as to what government ought ultimately to pay. So this was endorsed in an Ontario order in council, which was then sent to Canada. So this is the official communication from Ontario to Canada.
Your Honor, for your benefit, it's this letter from Mowat is in your compendium of documents to the demonstratives, tab 75. And Ms. Jones, was there any reference by Mowat to a limit to $4 as Canada had expressed in the order in council in its memorandum?
He's really talking about the principle here. He's talking about the broad principles rather than how much money and how much it would cost. So Canada's order in council did refer to $4. Mowat's description is the increased annuities which they claim. And again, he's referring to some round figures, but I think what he's really focused on is the principle of who is going to pay.
So is the answer no?
Yes.
Just in your view, having read that. Thank you.
Could go to slide 66.
Just after this order in council has been prepared, the Ontario Commissioner of Crown Lands produces some more definite estimates. It's $110,000 in Crown Lands revenue pre-Confederation, $282,000 after Confederation from Robinson Superior Territories. But he says he can't estimate the Robinson Huron revenues because he required more information about the location of the boundary of the territory. And then there's a sad tale of letters getting lost and misdirected. And the short story is that there was an estimate of Robinson Huron revenues, but it was not received in the Indian Affairs Branch until 1877.
And was the request for the boundary made to Canada.
Yes.
Slide 67.
So now it's Canada's turn to respond. Their Minister of Justice, Edward Blake, endorses a memorandum on Canada's responsibility to pay increased Robinson Treaty annuities, provides an opinion. And he's clearly discussed this with Mr. Laird, because it says in that first paragraph that I quote there, that he has had papers to look at, and as well, he's discussed it with the Minister of the Interior, who is the minister responsible for Indian Affairs at this time, David Laird. And in Blake's opinion, he says there seems to be no doubt that for some years back, the full augmentation up to $4 a head, so he does refer to $4 here, has been claimable. He believes that the liability to Indians comes within the 111th section of the British North America Act. And this, whether or not Canada be entitled that the lands in question are under the 109th section charged with the satisfaction of that liability. So he is, he's saying that's very tortured language. He said he's essentially saying that regardless of the interpretation of the 109th section about the trusts, that Canada has a liability to the Indians, which comes within the 111th section. And that the government of Ontario has repudiated any such charge. This has been discussed at the arbitration, but that Ontario acknowledges that the Indians are entitled to the increase. And Blake goes on to recommend that therefore that Canada should settle with the Indians without prejudice to any question as to what government ought ultimately to pay.
Into slide 68. Before you continue, Ms. Jones, for your honor's benefit, this is Blake's opinion, joint document book tab 3076, and in the compendium of documents to the demonstratives at tab 77.
Thank you.
So he recommends in his memorandum that the suggestion of Ontario be acted upon, the increased annuity for the current, I believe that should be the current year, should be paid without prejudice. So in other words, he recommends that Canada go ahead and pay, and that they work out the liability of where the money will come from later on.
Turn to slide 69.
I might, just before we dash on slide 68, Blake refers again to the general policy of the Canadian and British governments with reference to the Indians. So again, that's drawing a thread back to the imperial government's relationships with the Indians, of which the Canadian government is the heir. Now we can go on.
Slide 69.
Now we have David Laird, the Minister of the Interior, Superintendent General of Indian Affairs, endorses his own memorandum to Cabinet, saying that he concurs with Mr. Blake's opinion. And Laird at this point is getting down to specific numbers and dollars and cents, how much it's going to cost. Because he has to, in this order in council, allocate a specific amount from his parliamentary appropriation in order to pay increased annuities. He says that in his opinion, Canada should pay $4, which he considers the maximum, to everyone on the Robinson Treaty pay lists, starting with the year 1875. That there will be an annual parliamentary appropriation that will be necessary in order to meet that expense, because it's not included in any capitalized amount. He says that essentially we'll pay that out of our parliamentary appropriation unless it be decided or by any other mode of settlement that that amount is to be paid by Ontario or by the old province of Canada. And this is endorsed in an order in council of the 22nd of July, 1875. So in September of 1875, the checks were sent out to the field officers responsible for paying the annuities. The actual payments took place over a period of time extending into 1876. And then payments of $4 per person were made regularly at the treaty annuity payments starting in 1876.
Your Honor, tab 78 of the compendium of documents to the demonstratives is the memorandum to cabinet of Mr. Laird.
Okay.
And tab 77 of the compendium of documents to the demonstratives is the order in council just referred to.
Thank you.
We're on slide 70 now.
So now we have payments of $4 per person being made. But the question of whether they should have been made in previous years is raised, because certainly the Indigenous beneficiaries of the treaty have been claiming for a number of years that the increase should have been made. It appears that Mowat acknowledges that there might have been the conditions enabling an increased payment before 1874. The Minister of the Interior has acknowledged that, at least from 1874, but possibly earlier, there should have been increased payments. So in July of 1875, the Deputy Minister of the Interior, Mr. Meredith, writes to a Member of Parliament, E.B. Boren, who has been putting forward the claims of Robinson Treaty beneficiaries to an increased annuity. So Meredith writes to tell Mr. Boren that Canada has indeed increased the Robinson Treaty annuities to $4 per person. And then he goes on to say that the subject of the claims of the Indians to arrears of annuity at an increased rate will be brought up for early consideration. He says we recognize there could be, it's possible that we should have paid more money in previous years, and we're going to look into that soon.
Now, had this document been a document you referred to, I believe in your phase 3 report at footnote 129, had it also been a document you referred to in phase 1 of this proceeding?
Yes. And there was some discussion at that time about how to read this document. I had a copy available to me at the phase 1 trial, which was in which the word arrears of annuity was partially obscured. For this phase 3 trial, these files are now online in clean, fresh microfilmed copies. And I had a better, more readable copy available to me, in which the key word in this sentence was now legible. So I believe that both the version used in phase 1 and the version that I produced for the purposes of this trial are in the joint book, if you wish to compare them. I also went to the official departmental letter book just to confirm what that copy of the letter said, as there that the complicating factor in all of this is that that particular letter was reprinted in a compendium created in 1894 for the arbitrators. And the version in the compendium, it has different wording than what turns out to be in the original letters. So I went further to the official departmental letter book, of which I believe you have a copy now.
Yes, but just for
Yeah.
her owner's benefit, can you explain what you're identifying as the distinction between phase 1 and phase 3 that we're trying to address, aside from the point on the bullet?
In terms of the document?
Yes.
Yeah.
Just in case she's not understanding or following what you're
Right. I
saying. the
mean, we can,
discrepancy is.
it's easy enough to see if you want to pull
Sure.
up these
No,
tabs.
just tell me what you're pointing out.
It's that the word arrears in the copy I had in phase 1 had a blotch over it.
Right.
So it was hard to read exactly what it was. So
And
at
what
that
did-
time,
What did we all determine was under that blotch?
when I was asked, and I puzzled over it again, I decided that the word on the microfilm version that I had in front of me was indistinct, and therefore that I somewhat preferred the version that had been printed in 1894, because the process was at that time to hand over files to the people who were going to be responsible for typesetting.
Just tell me, what did you prefer? What was it, the word that you? thought it was?
Arrears.
Arrears. So in
And-
phase 1, you thought it was arrears?
No,
and
in phase 1, I thought it was increase. Because
Increase.
that's what was printed. And I thought, well, whoever
Okay,
saw the letter would have seen it without the blotch over the keyword. So let's go with increase.
okay, so even, so
Right.
just that in phase 1, you thought the word was increase, and now you are certain that it is arrears.
Arrears, yes.
Okay.
Yeah, I
thank you.
have changed my view on that.
Okay,
And just for the benefit of the parties, the documents she's referring to, Ms. Jones is referring to are JB tabs 2838 with the blotch and JB 2201 without the blotch. I don't think it's controversial for the purpose of why we're discussing this letter in this bullet, but if anyone has an interest, we also have the letter book copies that Ms. Jones is referring to.
thank you.
Ms. Jones?
Uh, So that was July of 1875. So a little bit more than 2 years later, September of 1877, the Auditor General writes to Mr. Meredith, of the Department of the Interior, asking if Canada intended to go into the question of arrears at all. And Langton suggests that if Canada was going to investigate whether arrears should have been paid, that there could be 3 ways of doing that. He suggests that Ontario engage with Canada to create a process to calculate net revenues from the treaty territories to determine for what years arrears were payable. Or he says we could have a new treaty, including Ontario as a party, in which then both governments would be parties to a treaty with the Indigenous peoples. And therefore, there would be some arrangement, in his view, where either the province of Canada or the province of Ontario would contribute to the annuities. Or option number 3, Canada can reach an agreement with Ontario as to a definite sum chargeable to it annually irrespective of the actual annual cost. So he's saying if we're going to talk about what was owed and what's going to be owed in the future, we have these three options. We can either do it year by year. We can come to a completely new arrangement, including Ontario, a new treaty, or we can work out just a flat annual payment every year from Ontario.
We pull up that document, Ms. Jones, to just highlight that language, and that's at JB 2846. And in your honors compendium of documents to the demonstratives, tab 81.
Thank you.
This is Langton's letter, where he's asking the Department of the Interior what they intend to do about these arrears payments or additional payments under the Robinson Treaty. He says, if we're going to be responsible for arrears, we need to ascertain the facts. In other words, in what years there was a sufficient excess of revenues over expenditures. And then if you go down a bit, said we need to know the revenues, we need to know the number of Indians. We're going to have to figure all this out for previous years. And he says, I assume we could obtain these facts from the province of Ontario. And we know how many people we're paying, so we could contribute that data. And then if you go on to the next page. As I say, in his view, before Confederation, he thinks it's going to be a charge against the province of Canada. After Confederation, in his view, he thinks Ontario is going to pay. If you go further down, then he suggests these other options. The only other course which could be followed would be a revised treaty, to which Ontario should be a party, or an agreement with Ontario as to a definite sum chargeable to it annually, irrespective of the actual annual cost. That's to cover the increase.
Can you remind us again, is this a internal correspondence to Canada?
Yes. So Ontario would not have seen this. This is to the Auditor General, to the Deputy Minister of the Interior. So this is from one department head to the other.
You can go to slide 71.
To or from the Auditor General? From the Auditor General to the Deputy Minister?
Yes.
Thank you.
And the Auditor General at that time is
Still Mr. Langton.
we're on slide 71 now.
In the meantime, the beneficiaries of the treaty are still petitioning for the payment of the arrears. So we have $4 now, but it's only since 1875, and that can't be right. There must be money owing from previous years. So at that time, the Minister of the Interior replies that Canada is waiting for information from Ontario. And then in September of 1878, the government changes again. We're back to Sir John A. Macdonald and the Liberal Conservatives. The old Liberal government is out. MacDonald becomes the Minister of the Interior and the Superintendent General of Indian Affairs. So again, as part of the process of new governments, starting or restarting old files. It says in early 1879, Canada again requested Ontario to provide information about the net revenues from Robinson Treaty territories. And this time in April 1879, Ontario replies with some statements of revenues from the Robinson Treaty territories. Now, I've summarized quite a bit of my report. Just very briefly, there were ongoing negotiations and discussions and meetings between Ontario, Canada, and Quebec on the Province of Canada accounts, including attempts to ascertain the amount owing for arrears of Robinson Treaty annuities, the liability for funding the arrears, and the annuity payments from year to year and going forward, which continued for the next 11 years on and off, but there was no agreement. That's the final conclusion. There are some interesting odds and ends in that time period, but I don't think we need to go through them, beat them to death.
And this is slide 72.
Yes, slide 71.
Okay.
Last bullet in slide 71 you're referring to. And returning to slide 72.
During this period of time, then, as I've said before, the Robinson Treaty beneficiaries were continuing to petition Canada for the payment of these arrears. And were assured by Canada that Canada would, quote, not neglect their interests. I took that from the response to one of the petitions, one of the letters. Canada would not neglect their interests in the ascertainment of arrears owing, and that their direct involvement in the process of ascertaining that the arrears was not necessary.
Before you move on, Ms. Jones, can we pull up that document, please? 2883, the JBD.
It's probably 2919.
This is in the compendium of documents to the demonstratives at tab 86 for your honor's reference.
Thank you.
You could take us to the text you're referring to, Ms. Jones.
Right, so this is a letter from the Deputy Superintendent General of Indian Affairs to Mr. Skeen, who is the Indian agent at Parry Sound. You'll notice that it does say draft on it, but I will explain a little more about that in a moment. If you can go down. The proposal had been that
Ms. Jones, just pause 1 minute. Your honor has volume 3.
Tab 86 is what I'm going to.
Yes.
Thank you.
there was an organization of Robinson Huron treaty chiefs and principal men, as they used to say. There was a general meeting held near Parry Sound, and there was a resolution that a delegation would go to Ottawa to make a direct representation to the minister responsible for Indian Affairs, which would have been Prime Minister MacDonald, about the payment of arrears. So the Department of Indian Affairs official response to this through their deputy minister was that the government of Ontario and the Dominion government are already in communication about this matter, and the visit of the deputation will not expedite the same in any degree. And Mr. Van Koenig goes on to explain that there are certain matters that have to be arranged between the provinces of Ontario and Quebec, which will affect their payments. Go on to the next page.
So Canada says,
Yeah.
don't bother to visit, we're on to it.
Yes.
Okay.
Now, it does say draft, but I can point out on the previous page that there's an initial. If you go a little further down next to the highlighted text, that's the initial of Mr. Van Koenet. His initial on these file copies indicates that he has approved it. And it will be rewritten, but recall at this time the amount of labor, clerical labor that's involved in making copies of documents. So normally what we see in the Indian Affairs files at this time are documents that look like this. They may have amendments or scratchings out or puttings in. But if they are initialed by, say, the deputy, or in some cases, the secretary of the department, that indicates that it's an approved final text.
You were on the second page.
Right, it just goes on to say that the claims of the Indians under the Robinson Treaty and other outstanding claims at the time of Confederation are being considered by the province of Ontario and Canada. And that the Indians should be assured that the department will not neglect their interests in this matter. And this is one letter, but in pages, I believe it's 105, 106 of my report, you'll see two enormous footnotes which refer to a great number of other correspondence, which is a very similar tone.
Yes, you're referring to pages 105 to 106 of your stage 3 report. And
yes.
that's footnotes 202 and 203.
Right. I just, on the slide, I just provide a little sample of what the general tone of this correspondence is. The response of Canada is that this is being looked after. We are representing your interests. There's no need for you to become directly involved or to visit Ottawa or anything of that sort.
And the footnote again is?
Footnote 202
Thank
and
you.
203 at pages 105 and 106 of the stage 3 report.
Thank you.
We go back to slide 72.
I believe it goes on to footnote 204 as well on page 106, if you're intending to refer to both pages.
Thank you.
We go back to slide 72. So I think before we had gone to that document, you had read the sentence, there is no documentation to suggest that the beneficiaries approached Ontario for redress.
Yes, I haven't located any. It is true that generally speaking, the records of the province of Ontario are thinner in this time period than there are the records for Canada.
So is it a better thing to do no documents yet found in a historical record?
That's right. I certainly haven't seen anything to suggest that. And I might further add that we have positive evidence that the Robinson Treaty beneficiaries at this time were expecting Canada and not Ontario to provide them with an answer or some redress to their claims. we have a letter from the Indian agent at Sault Ste. Marie, from 1886, February 1886. He wrote,
That's, sorry, Ms. Jones, if you're referring to it, I'll pull it up. It's JBD 2919.
yes,
And in the compendium of documents to demonstratives, that's tab 85.
thank you. Right.
First, can you explain what this document is?
This is a letter from the Indian agent stationed at Sault Ste. Marie. And it is written to headquarters at Indian Affairs. So if you could just scroll down a little bit. The Indian agent here is explaining that he is still receiving representations from Robinson Treaty beneficiaries about arrears and about additional payments. And this what the Indian agent is saying, that the substance has already been communicated in a letter from one I received from Mr. Dawson. And great dissatisfaction was expressed by some of them. The dissatisfaction is about the message they've been getting that there are negotiations going on between Ontario and Canada. So the agent goes on to say that the Indians state that the Robinson Treaty was made with the government of Canada and not with the provincial government. And it is to the government of Canada that they look to for the fulfillment of the treaty. So they don't understand why it is there's need to be negotiations with Ontario, the Indigenous beneficiaries.
And I don't think that we've referenced a date for this letter, which might be helpful. Do you mind scrolling to the top? And Ms. Jones, can you confirm the year we're referring to?
This is the 10th of February, 1886.
And the author and recipient of that document we just looked at?
This is from, if you can scroll down to the bottom. This is William Van Abbott, who describes himself as the Indian Lands Agent, but we would call him the Indian Agent, who is the field officer of the Department of Indian Affairs stationed in Sault Ste. Marie. And the recipient is the Superintendent General of Indian Affairs in Ottawa.
And then, do you know the name of that person?
That's in 1886 is still Sir John A. Macdonald.
Back to the slides, please. Slide 73. So it looks like we're making a change of topic at slide 73. To the legislation of 1884, slide 83.
I think, right, we can, this is something we can deal with fairly quickly. This legislation provides for the refund of the interest paid by Ontario and Quebec on the excess of debt between 1867 and 1873. So the interest money that they paid is a deduction from their subsidies. It's done in a little bit of a left-handed way, rather than just being one payment back to them. They add up all the interest plus 5% per year on each payment, and then set aside that amount of money in the Consolidated Revenue Fund to yield a 5% payment back to Ontario and Quebec twice a year. So I guess eventually they would get all their money back, but it's not quite as clean as here's a check, go away.
And just to ensure we're talking about that, we understand what you're referring to. Can you explain what you're saying, refunding the interest paid by the provinces for what?
That was
On
on
the excess debt.
any excess debt, yes. Over $62.5 million.
We can go to slide 74.
Okay, now we're really getting into some new territory.
One moment.
Okay. Given that negotiations had gone on really since the 1870s without any resolution to some of the outstanding questions about ascertaining the debt of the province of Canada, on the 28th of November, 1890, the Minister of Justice for Canada, the Provincial Secretary of Quebec, and Premier Oliver Mowat, as well as a flotilla of senior officials, meets to resolve some of the outstanding issues. And this is not only about the accounts or the various items on the accounts. There's a long list of other items and controversy in which they attempt to get some kind of a resolution. But among those items, then there is an agreement to submit all questions relating or incident to the accounts between the Dominion and the provinces of Ontario and Quebec, and to accounts between the two provinces of Ontario and Quebec, including claims made by the Dominion government on behalf of Indians and payments made by the government to Indians to another arbitration process. Musical interlude. And in 1890 and 1891, Ontario, Quebec, and Canada pass legislation and issue orders in council establishing this process. It's described in the legislation as, quote, being for the final and conclusive determination, end quote, of questions regarding the settlement of accounts. This is accounts driven, but without deciding any disputed constitutional questions.
Can we pull up, please, tab 2602 from the JBD, which is the memorandum you referred to? That is tab 90 of the compendium of documents to the demonstratives. Just want to ask you a couple questions about the memo that we didn't touch on.
Right.
So again, can you just explain the relevance of this date and who the parties are attending there?
It's, well, the 28th of November, 1890. This was a meeting held on that day between Sir John Thompson, who is the Minister of Justice at that time for Canada. Mr. Courtney is the Deputy Minister of Finance for Canada. Mr. Langelier is I'm stalling here. There's, he may have been the Premier of Quebec at this time. Mr. Mackin, I know, was the equivalent of the Deputy Minister of Finance for the government of Quebec. And Mr. Mowat, we know, is the Premier of Ontario, and other ministers unnamed on behalf of the government of Ontario. So this is a very high-level meeting. There's two sets of handwriting at the top of this document. One, it says note, and that is Emilius Irving's handwriting. The other handwriting at the top of the document is mine from 1987 or 1988, writing the archival citation on the document, which I wouldn't do anymore, but I did at that time. So it's.
You weren't expecting to see it again.
And
Right.
so what's, just want to make sure we understand that this document was about many things, not just about the arbitration.
Yes, so if we just scroll down a little, we can get an idea.
So it's between high-level representatives of government of Ontario and Quebec and is Canada?
And Canada, yeah, the Minister of Justice is there and the Deputy Minister of Finance is there.
Thank you.
There are a number of items here that don't have anything to do with the accounts or the arbitrations. For example, jurisdiction of county court judges to transact judicial business in other counties. Future treaties with Indians, number 3. At this time, there is a prospect of signing another treaty in Ontario.
Maybe
For
we can just go to those matters.
the north, right?
And can you tell us where we can find the references to the arbitration they're contemplating?
So this is a little further along. Yeah, this is a lot of this is about Treaty 3 in Northwestern Ontario, the confirmation of the reserves. Fisheries, public executioner, who pays for that? Foreshore, which is headland to headland in Treaty 3. And here we have item 15, the accounts.
Page 4.
Right.
Thank you.
Now, I think just scroll up a little bit here. Yes, this is item 14, actually refers to all questions relating to the accounts will be referred to a board of arbitrators. A little further down in this document, it refers to how those people will be appointed. In other words, one by Canada, one by Ontario, one by Quebec. The arbitrators are going to apportion the liability of Ontario and Quebec as to any claim allowed the Dominion government, and to apportion between Ontario and Quebec any amount to be found to be payable. So this is a little different in that Ontario, Quebec, and Canada are all going to be active participants in this province, in this process, as opposed to the 1870 process, which was really between Ontario and Quebec. In this second process, Canada is going to be submitting claims on behalf of not just the Robinson Treaty people, but there are other claims that arise out of events or documents preceding Confederation, which have been put forward. The idea is to submit those to this arbitration. So in this particular arbitration, Canada will be an active party.
And we also, do we see the selection of the statement of accounts to also include the owed to the Indians under the Robinson Treaty?
Yes. Again, can we just go, I believe it's, if you go up a little bit. Item 4. The claims made by the Dominion government on behalf of Indians and payments made by that government to Indians, that would encompass the Robinson treaties.
And if we could pull up now,
Sorry, item 4 on, are we still in this document? On
Yes.
Page 2?
page 4.
Page 4.
Oh,
It's a-
item
it's a
2
sub-
below. That's 15 sub 2
Yeah,
perhaps, or
15 sub
4?
4.
Now, Ms. Jones, you said just a moment ago, in this second process, Canada is going to be submitting claims on behalf of not just the Robinson Treaty people, but others.
Yes.
They're submitting claims on their own behalf, aren't they, with respect to their own obligations? They're not submitting the treaty claims to the arbitration process. They're saying who is responsible for these obligations?
Well, that's going to be a topic of discussion.
Okay, oh, so it's not obvious, you're saying.
when the arbitrations begin, that question will be raised, is on whose behalf are you appearing? Are you here for the Indians? Are you here on behalf of Canada? And so that is part of the questions that will be raised before the arbitrators. They will be claims arising from actions or events or documents prior to Confederation. And so the issue will be the arbitrators in this phase of the process did, in some of these claims, decide whether or not they believed the claims were valid
Mhm.
against anybody,
Mhm.
as well as apportioning who should pay. So again, maybe it would have been open to Canada, say at that time, to submit some of those claims to another judicial process or to make its own decisions on validity. But there were some claims that on which the arbitrators expressed an opinion as to whether or not they should be paid.
And at least in this memorandum, you've identified that the language used is on behalf of the Indians.
Yes, the language is on behalf of the Indians.
Okay.
Mr. Schachter?
Yes, I'm on my feet because I think we're getting into an area that on the face of the judgment is res judicata in terms of who was representing who and whether the Anishinaabe were parties to the arbitrations. I believe it's in the judgment.
Which is why I raised it,
Um,
which might not be known to this witness.
Yeah. So I don't know what to do about that, whether my friend is going to be making, I mean, there is the provision in law that says notwithstanding findings there, the court retains jurisdiction to ignore res judicata in exceptional circumstances, but I'm not inviting my friends to do that.
Right.
We're-
I just don't know, Ms. Glasser, if you are intending to develop with this witness some argument in that respect.
Right, at the moment, we're going through the background documents that led to the second arbitration process.
No, I'm asking you your intention. I said, I don't know if it is your intention to develop this with the witness. This being that Canada was acting on behalf of the treaty beneficiaries.
Canada made representations at the arbitrations that we'll see, but that's the historical record as between Ontario and Canada. We're just reviewing that record, what
Okay.
that might mean.
Yeah, any chance you understood my question?
Well, I understand that Mr. Schachter is saying.
No, I asked a question.
We will be discussing and reviewing the records about Canada's representations made to the arbitrators and to Ontario about the claims.
Is this a good time for the lunch break?
I was going to finish one more document, which is related to this one, but we can go over
We'll
to
take
the
it.
lunch. Sure.
Yeah. How are we doing time?
Actually, pretty well.
So an hour and 15,
I'm fine for an hour and 15.
1:45. Let's do that.
All rise. For recess until 1:45.